Hey everybody, welcome back to the Court of Random Opinion. And just for this group, I'll say it again. Welcome back to the internet where your cesspool is my jacuzzi. What's going on, guys? Sorry I'm so late tonight. Like I said, I saw that video where Gabby was again doubling down on roasting Clayton's appearance. And I had, made some comments about that, and I got roasted for it. People were calling me a pick-me girl and the wrong kind of queer, as if there's a wrong way to be queer or whatever. That's not even how I identify myself. So I don't lead with my identity. I'm just a person. And so that was frustrating for a minute, but I made my own little video response to the situation and how I feel about it, and how this situation that I'm invested in is much deeper than Clayton, even though I do really like Clayton. And he obviously has done a nice thing for me. So I decided to post that. So that'll be up in about an hour or so. I'm phrasing. What do you mean I'm phrasing? I say lots of things, so you're going to have to be specific. Bruce might join me if he can. I don't know if Schnitzel Ninja can because she has some other obligations tonight. I know Megan is busy with Tug. I'm turning my fan on, sorry. So it might just be me solo, which I understand is not as appealing, but here I am. So you might just be stuck with me for a bit. It was pretty bad when she said that. But like I said, I did a whole video on that. We're not going to talk about it right now because if you want to see that, it'll come out at 9:45 tonight in less than an hour. So, okay. Anyways, people were really harsh on me on Instagram, and I texted Dave. I was just like, dude, I don't know how you do this because people are fucking nuts. All right. Anyways, I have the podcast up right where we left off. Wow, I can speak. Hang on. Let me just share my screen here. Once again, thank you to Reality Steve for letting me use this. He said I could play the whole thing back and he wouldn't sue me, unlike the lawyer to his right there. So let's see how it goes. Teresa has a surprise. Wait, what? The less he knows, the better for Clayton. There's nothing like surprising the other side's lawyer with evidence they chose to ignore. I don't know what you're talking about. Anyways, let's move in, shall we? And I might, while I'm editing the video that I just made, cut out for a minute, and you guys will just watch it through, and I'll pop in and make comments. So if you see my face disappear, that's why. All right, let's do this.
Laptop, absolutely required by the disclosure rules. Nope, was never given that. And I've never seen that evidence. And Rachel, I don't know if you're aware of this. The PDF.
When all of a sudden she was no longer pregnant anymore.
Okay, so
I needed to make sure I understood what he was saying, so I just wanted to start that sentence over.
Hold on, you gotta hear me out. The fact that she has a history of appearing to claim. Have you read her communications with Gillespie and Maricini?
I've not.
Okay.
I've read some of them.
Huge problem, right? In debating this issue. I'm not saying you can't successfully represent her on appeal without reading that. Of course you can. But in terms of this conversation, I mean, from just taking Maricini alone, she claimed to be pregnant for months after having multiple abortions, according to the documents.
Well, okay, so
right?
This is
why I changed my tune when it came to this debate even happening, is because Reality Steve had Rachel Juarez on, and I was like, she's going to eat him alive if he lets her talk, which he has problems with apparently. And like I said, I haven't seen this yet, guys. So I've seen bits and pieces of it, and I've seen what we saw the first 30 minutes or so the other night with our friends. And speaking of friends, let me invite Omar. I'm going to play this for you, and I'll invite Omar while we speak. How about that?
Wait, hang on.
Hold on. The fact that is so ridiculous certainly tends to suggest, bar for relevance is very low, you know that she was not actually pregnant and didn't believe she was pregnant.
Okay, couple things. This is one of those issues where I don't want to get into a debate over evidence I've never seen. Do I have a document that says it's text messages? Yes. Was I ever provided with the original laptop, absolutely required by the disclosure rules? Nope, was never given that. And I've never seen that evidence. And Rachel, I don't know if you're aware of this. The PDF that Woodnick disclosed to me was totally insecure, such that you could go in and change the wording on any line you wanted. I did. I used an example. I went in and just typed some crap and saved the file. So I'm not saying, and Maricini actually filed a bar complaint against me where he said I accused him of fraud because I raised that possibility that somebody might have tampered with this PDF. I never said that he did. I don't know. I never had a chance to investigate that, is all I'm saying. So you're sitting here telling me, well, Laura said this and
what? What do you mean you never had a chance to investigate that? Oh no. Oh no. Focus, Lauren. Focus.
These messages, you have no idea if those messages are real or not at all. You don't. You think they are, but you don't know. And here's ultimately why I'm so strongly disagreeing with you. You clearly believe that that witness credibility is relevant in a paternity case. And what I'm saying to you is there is no situation in which a woman could win or lose a paternity case based solely on her testimony, ever.
What do you mean win or lose a paternity case based solely on her testimony? What do you mean by that?
A paternity establishment petition cannot be adjudicated based solely on the testimony of the mom saying, I think I'm pregnant. You agree with me? Yeah.
Absolutely. Okay. However, many issues in a paternity proceeding can turn significantly on credibility, including the parenting time request that your client asked for.
That
if you have someone
the court never ruled
credible,
that the court never ruled on. The parent.
That's the face I make when I'm trying to understand something in David's legal filings.
Time that never became an issue because there was no baby to have a parent.
And the reasonableness of her positions when it comes to attorney's fees.
Okay. Anyway, I maybe we should move on from this topic because you and I are clearly not going to agree on this. The way I see it, Rachel, is there has to be a causal.
Yes, we should move on from this topic because we're not going to agree on this, and I have nothing left to stand on. Hello, Leg Warehouse. My friend David needs something.
Link between the person's bad conduct and the fees that you're claiming that you're looking for.
Do you have case law on that?
Oh, of course.
That there has to be a.
But did you read it,
when
David?
You're talking
did
about
you read the case law?
In California, it's not the case. You do not have to establish a causal link between specific fees and unreasonable conduct. They have to be related in the sense of I can't go out and spend fees investigating, a separate tort claim against another person. But you do not have to establish that the unreasonable conduct caused specific fees.
I will get back to you on case law for that. Okay. Can we move on?
Get back to her. It's a podcast, you wad.
Topics. Steve, you're the moderator here.
Yeah. I mean, we're going to have to somehow tighten this up because
Steve is exasperated.
Just spent 38 minutes on the first question, which was, why didn't you cross-examine Clayton? Now, we did get into other stuff that we were going to hit on later, which was,
Maricini. You were going to ask me about Maricini.
The takeaway, hold on. So the takeaway from that is not that it was a deliberate decision. It was you had to kind of figure it out on the fly.
Hey, Chrissy.
And you kind of made a call on the fly, right? That it would be more important to use your time with Laura.
I did not believe and do not believe that Clayton's testimony had anything to do with anything that I needed to prove or disprove.
Oh.
I didn't.
What? Sorry. What? How about the fact that they only had oral sex?
I didn't see the value in it.
Got it.
I wish we could have gotten that.
I, lawyer for the petitioner who lied about her pregnancy, didn't see the value in asking the man who she said impregnated her falsely about whether or not they actually had vaginal sex. What a moron.
5 minutes.
Sorry, I don't mean to say mean words about David. I'm trying not to do that anymore. Yeah, I failed.
Instead, we really, it was almost feel like we're at the trial because we just spent 40 minutes when we're on somewhat of a time crunch. But
all right, let's move on.
Stuff up. All right, let's just get to the Maricini stuff. Pre-trial, you explain the story of everybody is very well aware that you called the Arizona Police Department to have him taken away, arrested for showing up to a trial that he was subpoenaed to be a witness to. Go.
Yeah, he was not subpoenaed, first of all.
Oh, so that was a lie. There's your first lie. I'm sure there's more to come.
It was not. Arizona subpoena is not valid to compel a witness to appear from California.
Rachel seems to have something to say about that.
Rachel, you disagree?
He was served with a subpoena.
From California?
Subpoena.
From California?
Hold on. You say he wasn't subpoenaed. Okay.
Not a valid subpoena.
He was
No.
not served with a subpoena that could have been enforced, is what you're saying.
Correct.
If you declined to appear.
Correct.
I understand that you're saying that.
So
Rachel's very fair.
You're saying it's cross state lines.
So here,
you're stupid, but you said something technically correct.
this was part of Mauda's bar complaint against me, Steve. I
casually dropping that an acting sitting judge has a bar complaint against you is such a flex.
assume that you're very familiar with that. And she said, well, she said, I forget the wording of it, but she said something like, I'm not going to find witness tampering, but it looked like, what did she say? Do you remember what she said specifically?
I don't remember the wording of it. No.
So witness tampering, you can't like threaten a person and say, oh, if you come to trial, I'll burn your house down. I mean, that's you.
Well, I'm certain he said that to someone at some point. I don't have any proof, but I just feel like that definitely happened.
You can't, it's witness intimidation.
He seems like a learn through experience kind of guy.
Can't do that. So what happened behind the scenes, and I assume that you guys are familiar with these facts by now, that I get Woodnick's bare bones disclosure statement where he says Maricini's a witness and he's going to say something about something, which is a violation of our
we all saw the documents. That's not exactly what happened, but go on, sir. I guess I have to listen to you.
disclosure rules. You have to list a fair summary of what the witness is going to say. Woodnick gave me no details at all. So I find this out and I pick up the phone. I call the only person listed as a contact for Maricini is his lawyer in California. And she goes, I don't know who you are. Maricini.
How dare you not know who David Chingers is? I was on Dr. Phil.
Not coming to trial. He's never heard of this case. We have nothing to say to you. I said, great. Can you send me something in writing to confirm that? And she did. This Randy Sue Pollock. Okay. So she sends me an email. She says, he's not coming. Great. I just scratched that off the list. I then, days before the discovery cutoff, get this 2,500 page text message drop from Woodnick saying, oh, Maricini is going to come to trial and talk about these 2,500 text messages that you've never
Imagine someone changing their mind based on evidence.
Seen before, 2,500 pages of text messages. I immediately then tried to figure out, I went back to Randy Sue Pollock, said, is he coming? She said, we're not going to talk to you, which is not okay under what Rachel, what's the eyebrow?
You think that he has an obligation to talk to you?
Absolutely. Discovery was still open. Discovery was still.
So you had the right to depose him.
Absolutely.
He doesn't have an obligation to voluntarily be interviewed. You could have
which is
exactly
like absolutely I make when I'm about to
you don't
drop
have the
shit,
right
David.
to have a third-party witness submit to an interview.
Wow. Stop.
Yeah.
That is exactly.
Stop, Rachel.
The conversation that I had with Randy Sue Pollock. What I said was, I need to depose him, or he can talk to me. You can choose to be voluntarily interviewed if you don't want to be deposed. I was willing to do whatever was easiest. She said, you're doing neither. She said, you're not, we are not.
Guys, I need Bruce's contractors to leave so he can come talk to us.
letting you talk to Mike. Okay. That's not okay. And more importantly,
wait. Hang on.
Exactly. Which is
it's like absolutely basic law. You don't have the right to have a third-party witness submit to an interview.
Wow. Stop. That is exactly the conversation that I had with Randy Sue Pollock. What I said was, I need to depose him.
So you learned your lesson the
first
time, and then you still shit the bed.
You can choose to be voluntarily interviewed if you don't want to be deposed. I was willing to do whatever was easiest. She said, you're doing neither. She said, you're not. We are not letting you talk to Mike. Okay.
She's like, okay, so
that's not okay. And more importantly,
her facial expressions, they're very like slight, but they say a lot, and it's killing me.
The Arizona disclosure rules require substance of the testimony to be disclosed. I'm not supposed to be guessing on what he's going to say. Woodnick gave me nothing. Under the rules, I'm entitled to object and say you just say non-disclosure. This hasn't been.
We got to move on because
hang on. I'm giving you
shows up.
Oh, no. So when she wants to move on, he's like, no, hang on. But when he wants to move on, they're supposed to just stop everything and just okay.
Right?
I'm giving you context that there were reasons why I had valid objections to him being there. Non-disclosure being one, absolute non-disclosure.
So Woodnick's failure to disclose was part of the reason that you felt justified in calling the police when you came?
Stop. Can I finish? I'm not even close to
Don't pretend you didn't finish 4 times already, David. Come on.
finish.
Well, that's part of the problem.
Well, if you let me get there. Let me get there. So I'm behind the scenes having communications with Randy Supalik, trying to get, all I wanted to do was get proper disclosure and an interview with the guy or a deposition. Either you take the pick. They just told me to pound sand. I then tried to talk to Woodnick about it. Guy wouldn't talk to me. I then requested a hearing in front of Mata so this exact issue could be raised, which the rule required her to set. She denied that. I then told Woodnick, we have a problem. We cannot have this guy. We have a valid court order that says he cannot be within 300 feet of Laura. I'm not saying that, and
within 300 feet of Laura, as if that isn't a hazard to every other man on the planet.
I said this over and over and over in emails to every single participant involved. I said, I want Maricini to be there if he has a reason to testify.
You said you want him to be there? Oh my God.
He can come to trial. He cannot be within 300 feet of Laura, ever, period. And they just said, go F yourself. So Laura.
I'm certain that's not what the actual professional attorney's office said, but go on.
That morning said to me, if he's here and is within 300 feet of me, she goes, I'm not going to stay at the trial. I'm just going to leave. So I said, what can I do? She said, I want the police to come and enforce this order. I said, okay, I'll try. So I tried every single possible thing. I called court security. I said, look, we have a court order. Here's a copy of it.
Which was entirely unnecessary as someone who was there. What the fuck are you doing? Like, just stop.
Here's federal law. The Violence Against Women Act said the order shall.
And here's where I get really mad. Because they try to exploit the Violence Against Women Act for Laura's benefit. Laura, who has never been harmed at all by any of these men, by the way, and I say that with my full chest, and I say that as a fact. So fucking sue me, Laura. All right? Laura, who has never, ever been violated by any of the men who were accused, including Clayton, Greg, and Mike. Okay, I don't know the other guys, but I'm pretty sure they didn't do it either. That's just my speculation. But as a fact, Clayton, Greg, and Mike never abused Laura in any way. She fraudulently got restraining orders against them by using false evidence that she stole from another person on YouTube, that she had a Fiverr logo on, all the above. And she, at one point, apparently, per David Gingras, stole her sister's ultrasound to use. So, citing the Violence Against Women Act is out of pocket. Fuck you. Keep that out of your mouth. That's meant to protect actual victims of sexual assault and violence, actual victims of sexual harassment, actual victims of crimes against women. And your client is not one of them. So you shut your little fucking mouth. All right?
I'll be enforced, full faith and credit. Mata had no authority to disregard it, which she did. And I just tried to ask the police to enforce a facial court order. They then talked to Mata. She says, don't do it. I still maintain, I think that was illegal.
He did not just say a facial court order. I mean, Clayton did it for free, but a court order, I'm not sure if that would get her the dating contract she's looking for.
I think that was a crime, but people don't agree with me.
Okay.
So look, I never said the guy can't testify. I just said he can't be within 300 feet of Laura. So
how is he going to testify if he can't be within 300 feet?
Let Laura leave the room. Let him be in a different room. Let him.
You had the option, you dumbass.
Why couldn't you have just asked the judge to let her leave? Rather than
when did I get a chance to do any of that?
During the court hearing. Oh my God, what a weirdo.
I'm asking you.
That is, well, if you go back and look at what I made an opening statement to the court at the beginning of the trial, raising these exact issues, and Mata just didn't want to entertain any of it. Okay. If she had given me options, I would have considered them. We just didn't. We did the best we could with what we had. Asking the police to enforce a valid court order to me is a not controversial thing. I mean, I just should have ignored it. I just should have said, sorry, Laura, California court orders don't apply in Arizona, even though there's a federal law that says they do. I don't know what you
should have said that. But I think you might have said to your client, we're not going to call the police on him when he's here to testify. And we've known for months or weeks, I don't know what it is, that he's coming to testify.
Days.
At that point, it was days. Okay,
yes.
So she should have been prepped that he would be there and not have the police called when he came in.
Okay, I just agree to disagree. There's nothing. Anyway, we'll just see it. We see that differently. And again, Mata did what she did, and so far nobody cares about my arguments. That's not really part of our appeal. I understand it's part of the bigger picture, but
just as a layperson, we did have security officers there. We did have police officers. What did you think was going to happen? What did she think was going to happen? He was going to jump over benches and attack her? What? Come
Steve,
on, let's just be honest here.
Steve,
what was going to happen?
First of all, you're asking a question that should be answered by Laura, not by me. But all I can say about that is she had a court order that said this man is not allowed to be this close to her. Why did she want the court order enforced? Why wouldn't she? Why should she have to give up her rights because we just don't like her very much? It's anyway. I don't agree at all with what you guys are saying, and you don't agree with what I'm saying. So I just didn't want Maricini to be there and intimidate Laura and scare her just by looking at her. I don't care, Steve. If it was just bringing back bad memories, okay? Laura should not have to suffer through that just because Clayton was on a TV show, okay? That doesn't give him some superior right to make Laura feel the way that she felt.
Nobody's claiming that it does.
Really?
Yes, really.
Okay. All right. Well, we're moving on to the next question. We're not gonna get very far with that. So
okay. So I guess we'll move on from the trial. We know what the trial's decision was, and then obviously we'll just get to the most recent thing, which was the Court of Appeals denial. And you lost again. You kept your streak alive of losing in this case.
Which, by the way, you said there was 0% chance.
0% chance. No chance in hell that Clayton was going to win this appeal.
What lawyer ever says that? If they're being taken,
I don't. Did I say 0%?
Yes, I played the clip. That's what I tweeted out. I have the clip.
Well, you're welcome that I gave you that's such an easy way to roast me.
Yeah,
guys, look.
Yeah.
But why did you say it when you? My problem was
because I believed it.
The actual fact was that
I have no problem with you believing your client was going to win.
Or I think I'm going to win.
It's the presentation of it when you made it seem like there was 0% chance when you've been in many litigations. You know it's a possibility you might not win something. I know you're projecting confidence in winning, but it came across horrible, and then we ended up being right in the end.
Well, that makes it that much sweeter at this point, but it ain't over yet, Steve. It ain't over yet. We may still get a 100% victory for Laura. We don't know.
Makes what sweeter? Because I would love to know what seasoning to put on the bullshit I like to eat. I mean, come on, man.
So I could be right. I actually could wind up being right. We just don't know yet.
We're talking about the appeal.
There's no chance you lost this appeal.
Yeah.
And that appeal has been lost. Right now you elevate it. Obviously, something could change. I would never say there is a 0% chance that you will have this.
Rachel, here, can I offer you like a cookie or something? What do you want me to say? What do you want me to say?
Not that. Let's say 0%. Just say you're confident in our case. We like.
Why would you say something so condescending and misogynistic in the middle of all this? All you have to do is try to make yourself look a little better. Oh my God, he looked better when he looked dumb, not just misogynistic and dumb. I mean, what the fuck? That was insane. All right, I'm going to let some more play. Unfortunately, I only have 10 more minutes, guys. 10 more minutes on this stream because I have another thing that I have to do. But I will go for another 10 to 15. How about that? And then hopefully on part 3, I'll do it on Saturday. Part 3 will be on Saturday so that friends can watch with me because just me is like, it's not as exciting. Not exciting even. Not as funny. Like I'm not having as much fun just doing it by myself. And if it weren't for everyone in the chat watching, I definitely wouldn't be doing this at all because holy hell, why would I want to listen to this?
Like our case, we've made a strong argument. I really like my appeal. And I think we have a good chance to win this thing. But to degrade everybody who says you're going to lose and everybody who says who ended up all being right, to just do it the way you did it. I'm just saying you could have taken a more tactful approach. You don't agree with that?
I hear what you're saying. Steve, we're living in weird times, man. I've been drinking too much Trump Kool-Aid, which again, I don't like Donald Trump. This is sarcasm.
I'm sorry. What the fuck does that have to do with anything?
Does Donald Trump ever say, "Oh, I'm going to lose the election" or "I'm going to lose this criminal case"? Or
it's why a lot of people don't like him.
That's part of the sort of negative trend of society that I think a lot of us are not happy with where it's going, right? That instead of having reasonable conversations saying, I'm really confident in this appeal, I feel like we're going to win it, we're taking the Trumpian approach and saying 100% victory. I mean, that's why the world is going where it is. Why contribute to that?
I give you my unconditional apology for using bombastic language that was just too confident. I shouldn't have said that. Can we move on? Okay. Yeah. It's not really what we're here to talk about. I don't think.
Yeah. Okay. So the Court of Appeals.
But
denial.
You did it. You
so
said it.
Now we just get to
about it.
What did you think was wrong with the Court of Appeals opinion? Why do you feel like you were right in your appeal?
Absolutely.
And why do you think you will be successful in, if you are going to do, the latest news is, maybe you're going to break it here on this podcast, you're thinking of doing reconsideration, but even if you don't, you're going to go to the Arizona Supreme Court and then the U.S. Supreme Court. So why do you think your case?
Let's get into that. Let's get into that. So page 4, you said you had the ruling. We don't really need, I mean, this stuff is so dry. People that aren't lawyers.
You want the Court of Appeals decision?
No, you don't need to. Let me, if we need to refer to it, you can pull it up. I've obviously got it right here.
Yeah.
I'm just letting you know that on page 4, the court is, shoots down my Rule 26 argument and basically just bought into what Clayton said.
Imagine
that Rule 26 was not the basis for sanctions. Therefore, we don't
bought into it as if it didn't have merit. You fucking weirdo.
Don't have to talk about it. That's essentially the entire analysis, right? Where
there were alternative bases for
right. And I cited case law. Holgate versus Baldwin was my favorite one, but there were cases that I cited that basically said, and I'll paraphrase, that the existence of alternative grounds for punishing a person who violates Rule 11 or Rule 26 doesn't allow a court to disregard the safe harbor provision of the rule. A person has to be allowed to withdraw an offending pleading before they're punished for the pleading.
Only under Rule 26.
No, Rachel.
Read your case.
No, you're incorrect.
So take me to Colgate. Pull it up.
Are we really getting that detailed?
I read every single one, and not one of them says that you cannot punish conduct that could be punished under Rule 26 under an alternative theory of sanctions.
That is exactly what Holgate, or was it? It might have been Rainbow. Look, I'm not going to get into that level. Read the pleadings. You don't agree with it. You don't agree with it. But I'm telling you, the case law that I cited says that this analysis, you cannot simply disregard the safe harbor. When did Laura get her safe harbor, Rachel? When did she get her safe? You agree that there is a safe harbor.
She wasn't entitled to a safe harbor prior to being sanctioned under 25, I don't know, 809, I'm forgetting the number now, G, right? There is no safe harbor under the statutes that both Judge Mata and the Court of Appeals agreed she was sanctioned or Clayton was awarded fees under.
Okay, but do you agree with me? Do you admit that in Woodnick's first filing, he asked the court to grant Rule 26 sanctions? Do you agree with me with that?
I agree. At some point, he asked for Rule 26 sanctions.
I agree that you would benefit from shagging yourself.
It was in the very first thing. I don't mind telling you, I have that part memorized.
Okay. Yeah, I don't have any reason to agree or disagree with that.
And do you agree with me that?
Well, wait a minute. Hold on. But fees have been requested prior to that by Clayton in his response to the petition.
In the same thing, he requested sanctions and fees.
Clayton's handwritten response.
Yeah.
Well, he didn't have any fees.
There had been a request for fees pursuant to the alternative statutes prior to any Rule 26 motion being filed.
Which he didn't incur, but yes, I agree with that.
What the fuck are you talking about?
Rule 26 was not the first time that any of these statutes were invoked.
Yeah, okay, hang on. You're getting far afield here.
Okay. All right, guys. Like I said, I don't think I can do any more of this without Bruce. I know things got crazy tonight. I'm sorry I couldn't start as early as I wanted to, and I'm sorry I couldn't cover as much as I wanted to, but I will, no matter what, on Saturday night, be finishing the rest of the recap of this podcast. And by recap, I mean playing the whole damn thing and commenting on it. Hopefully, Bruce will be able to join me. If not, I will cry beforehand, and then we will go through it anyways. But I have another stream coming up in 9 minutes, so I gotta go take a little breather, and then if you're interested in the Justin and Blake stuff, join me there. If not, then that's okay. I'll see you on Saturday night for part 3 of this because I have a whole lot going on the next few days. But anyways, thank you very much for joining me, guys. And I am looking forward to seeing the rest of this with company because I cannot listen to any more of this on my own. All right. Bye, everyone. And please hit the like on your way out. I appreciate it. I'll still be streaming, Sarah. I'll still be streaming. It'll be a different stream starting in about 8 minutes. So bye. Oh, Tilted Lawyer's here. Bye, Omar.